station, its staff, management, or sponsors.
Welcome to the Ask the Experts Show with local experts in the fields of legal, health, financial, and home improvement. Enjoy being educated in such topics as personal injury law, community association law, family law, bankruptcy law, along with health show topics like pain management, men's health, and dental implants. Now, sit back and enjoy today's Ask the Experts with host Steve-O.
Hey, good afternoon, good evening, whatever it may be. This is the Ask the Expert Show. I'm your host, Steve-O, and I got to tell you, last month at this time, and by the way, we know we have a caller on the phone. We'll get to you in just a minute. We had the worst storm ever. I mean, it was horrible. We got knocked off the air. But I think we're going to have a great show today. This is our community association show. Kay Bender Rimbaum, who's been with us for about 4 years now. We have board certified Robert Kay, senior partner, on with us today. And it is literally my favorite show to do. We get so much of your email, and thank you so much for sending your questions in. And also for all the phone calls. If you'd like to call in, maybe you're a board member or you're a management company or you live in a condo or HOA, give us a call here at 888-565-1470. Kay Bender Rimbaum. It's a law firm that does community association law, and we want to welcome senior partner Robert Kay.
Thank you, Steve. Good to be here.
We had a tough time last time, didn't we?
We sure did. That was crazy.
It was crazy. The weather was, but anyhow, we're here. Looks like the weather's going to be okay. We've got so many questions. Phones are starting to ring. We do this every month, the first Thursday of the month from 6 to 7. And I guess everybody loves the show because we get so many people telling us how much they love the show. Let's tell everybody about your firm first.
Well, as I hope most of the listeners know, Kay Bender Rimbaum is a full-service law firm, but primarily focused in the area of community association law. We work out of our offices in Pompano Beach, Palm Beach Gardens, and Tampa. Pretty much covering all of the state for community associations and every aspect of their operations, the day-to-day issues that they are faced with, be it interpretations of their covenant, opinions as to their rights and obligations, dealing with owner violations, dealing with outside contractors, contract negotiation, litigation aspects, be it with owners in violation or outside vendors who have breached their contract, construction defects, collection of unpaid assessments, assistance in handling all aspects of the day-to-day operation of associations is what we do. And we do it with the mindset that we're a service business. We're here to provide our clients with fast, effective, cost-effective and efficient responses to all of their general legal needs.
Well, I guess our two callers got tired of waiting, so if you would give us a call back here, 888-565-1470. We are on social media during the week, and if you have a question, sometimes it's hard to drive the car and talk on the phone at the same time. We ask you to send your questions in, and it seems like every month we get more and more questions. And you're going to be talking about your calendar today for the month of June.
That is true. We have a lot of things coming up.
Okay.
Want to hear that now?
Hey, that would be fine if you want to. Well, we got a call coming in, somebody who was waiting before. So let's go to the call first. You know, I got to tell you something. I've been doing this for 7 years, and the amount of people who called into the show over the hour period, it just blows me away because we don't have that on any of our shows at all.
Well, it's a
We're
popular
looking,
topic.
oh my gosh. But you know what? It's just the show is a good show. I mean, you tend to, uh, I guess, address people's questions that they have. We're going to go to Michael first. Hello, Michael.
Hey, thank you for taking my call, and you are
Sure.
incredibly timely. I just happened to be surfing some channels, and I got a question for you, so thank you. I am about to close escrow on a condo purchase, and just came up during title, just today, as a matter of fact, is a $42,000 assessment that I'm a little shocked because and they're trying to add it onto the purchase, the seller's, the escrow account, and it is related to an assessment that was made within the last couple of months for roofing repairs that they have financed over a 12 or 13 year period that adds, I'm not sure, $170, $200 a month. But then me as a purchaser, they're trying to hit me with this $42,000 right up front. It was never brought to our attention. We do not have a real estate broker. This was a friend-to-friend handshake sale in which we grabbed our own title and escrow company. I'm absolutely bewildered as to how this could be the case if everybody that lives there is going to be paying, or are the prior owners will be paying this over a 12 or 13 year period. The seller was never notified about it. I was never notified about it. It was escrow. Surprise, $42,000. Any clue?
Well, it's not an unusual circumstance for an association to adopt a long-term assessment based upon financing and allow it to be paid out, but often, not all the time, but on occasion, they will structure it so that if there's a sale of any of the units, it's accelerated and everything's due and payable. It's unusual when it's a $42,000 one, so that's not something that we typically see. I would think that if you approach the board of directors on that and ask to be allowed to continue with the monthly payments versus an accelerated payment up front, they should be amenable to it. I presume that there was a preliminary application and review of the purchase agreement by the association so as to make sure that they were comfortable that you were financially able to meet the requirements of the association as they go through their regular assessments. So generally speaking, that should be allowed. When you do purchase real property, such as a condominium unit, it's always advisable to bring in independent expert title closers that will make sure that they get asked the right questions, because oftentimes that information isn't something that's going to be volunteered. You have to submit a request for an estoppel statement to provide you with whatever is outstanding on the unit before you go to closing, so that you can make your informed decision as to whether or not you do want to go forward with it. If they are not willing to allow you to participate in their financing program over the life of that and are insistent on demanding payment up front, it's possible that could be a sufficient basis for you to cancel the contract.
Okay. Yeah, we did use a title company, and even the prior owner was completely caught off guard on this. Let's say that I say, all right, fine, how is that handled? My unit is, that's over a substantial period, and let's say, I'm presuming I would, this assessment is, monthly. What if I sell the place in 5 years? How do they handle that? I mean, this just seems like a real can of worms. It also really makes a great difficulty for the current owners themselves to actually sell a unit if any incoming buyer is suddenly hit with this kind of slap. I'm really bewildered by this.
Well, what you need to look at, what you need to look at is the documentation of the adoption of the special assessment and the notification that was sent to the unit owners after that. The board meeting minutes at which the special assessment was adopted would need to incorporate the acceleration aspect of it upon the sale of the unit if they are providing this long-term financing to all of the unit owners. They may have structured it to allow some owners to pay it all up front, which is not unusual, in which case they would not be paying the same amount because there would be no interest accruing over the life of the loan. This is a long one, 12 years, so that could be a significant reduction to anyone who pays up front. And you want to make sure if they are insistent upon a payment up front that you're not paying interest over the course of 12 years as if you were participating in the long-term financing as well. Looking into those minutes would identify if they properly incorporated it, and then the notice that was sent to all the unit owners of the special assessment would also likewise need to state that. If that's not in there, then the board may be overreaching on this one.
Okay. And that's when they start overreaching is when I call you guys, huh?
Yes.
Now, my other question then is, what is our option for us to just have him do a quit claim and me to pay him and just tell the board, well, I'm now the owner. It was quit claim to me.
Well, again, it will depend on the documents. It'll depend on the manner in which they adopted the special assessment. It might yield the same result.
Okay, we got to go to break.
The burden of proof on them to come after me. Sorry, I'm an attorney from another state, so I'm trying to not litigate it from another state standards, but it would seem
Sure.
like it would be then the burden on them to come after me for this $42,000 if I were on.
Well, they have the power to. They have the power to file a lien against your unit and then a foreclosure action and take away your ownership for this amount and add on their attorney's fees and costs in pursuing it. And if you litigate it, all of those attorney's fees and costs could likewise end up your responsibility or lose the unit. So it seems like it's not your best interest to take that approach and to try and work it out up front. And if not, then perhaps it's not the place you want to purchase.
Yeah, no, I agree. I wouldn't want to go that route, but it is nice to know what the guardrails are, when it gets down to it. So I'm going to start digging back into the CC&Rs again and get the minutes when this was at this resolution to pass this assessment, which I think the assessment itself is legitimate, and I think the financing of it is very legitimate. I just don't understand how you would, as a group of owners, ever want to make it near impossible for yourselves to sell a unit because you're going to have this accelerated $40,000, $42,000 tagged onto any potential buyer. It really makes the alienation. Anyways, it's like restriction on a transaction.
Thank you, Michael. We got to go to break right now.
Thank you.
Let's go to break. We have a line open, 888-565-1470. Robert, give everybody the phone number and the website.
Number is 800-974-0680, or you can go to our website at kbrlegal.com. Write to us at info@kbrlegal.com.
We come back, we're going to go over Kay Bender Rimbaum's calendar for June. We'll be right back.
Kay Bender Rimbaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida, with offices in Pompano Beach, Palm Beach Gardens, Tampa, as well as in Miami-Dade by appointment. Several Kay Bender Rimbaum attorneys are board-certified specialists in condominium and plan development law, and they assist clients with all matters of community association legal issues while keeping them up to date on new developments affecting their associations. Kay Bender Rimbaum is also a well-known provider of free legal education, which often includes CE credit for managers and state certifications for board members. Contact Kay Bender Rimbaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or just write to them via email at info@kbrlegal.com.
And we are back. This is the Ask the Expert show. We're on every Thursday night from 6 to 7, drive time. This is the first Thursday of the month, so we always have our community association show with Kay Bender Rimbaum being our experts. One of the largest community associations in the state of Florida. Is it weird? Have you gotten used to saying Tampa yet?
Oh, yes. We've got 2 years there.
Okay. God, it doesn't seem like it's been that long. If you'd like to call into the show. Yeah, I know. So if you'd like to call into the show, you have a question for Robert, condo or HOA, 888-565-1470. We're going to do the calendar for Kay Bender Rimbaum for June.
Okay, we have a number of items that we're presenting in June, and they're all going to be via Zoom, so listeners can participate from the comfort of their home or office on these issues. Starting with on June the 9th, there's going to be an interesting topic called the latest on the 2021 legislative session. It's an informational discussion with attorneys Allison Hertz and Sean Brown, following up last month's webinar on what was pending. Now we're going to be discussing what was passed by the legislature, waiting for the governor's action and either signing or vetoing if that's a possibility. There are some things that might be good for the governor to veto, but whether or not he does, it's a waiting game. All of these will become effective July 1 if they do get through the governor. If he takes no action, they become law. If he signs them, they become law. But if he vetoes, then they will not. So June the 9th at 11 a.m. to 12:15 p.m., we have that discussion. And then on June the 11th, how to negotiate telecommunications contracts. That's a new one that we're doing. Andrew Black will be joining with Hotwire Communications and ACAM Property Management at 10 a.m. to 11, talking about various things and getting into these long-term bulk contracts for internet and cable TV. June 16th, we have a condominium board certification class at 10 a.m. to noon, 2C continuing educations for managers, and this will be taught by Lisa McGill. On June the 23rd at 12 noon to 1 p.m., Michael Bender and Campbell Property Management will present funding construction projects. Apropos to the last caller, that was long-term funding of a roof replacement. So this on June the 23rd at 12 noon to 1 p.m., we'll have a webinar on that topic. And on June 25th, we're going to come back and summarize the 2021 legislative session. Allison Hertz, hosted by Community Association Resource Group, 10 a.m. to 11:15 p.m. on Zoom. And then on June the 29th at 12 noon to 1 p.m., Association Leadership Session 2, or Season 2, Episode 18 with the Castle Group with Michael Bender and Jeffrey Rembaum at 12 noon to 1 p.m. And that's what's coming up in June.
Busy month. Busy month.
Yes. A lot of good stuff.
Okay,
you can find all that information on our website, kbrlegal.com. Click the calendar, and then go to any of those items that you're interested in to reserve your spot.
We have lines open at 888-565-1470. We're getting ready to go to your questions. If you have a question for Robert, just give us a call here, 888-565-1470. We're talking about community associations tonight, HOA, condo associations. Give us a call here. Our first question is from Guy in Royal Palm. He said the judge's orders case management conference. I've never heard of that. For the condo association. Can an owner attend that?
Well, it sounds like what Guy is talking about is an active litigation case. Sometimes in these cases, a judge will order a case management conference with the judge and the parties to go over various aspects of where we are in the case and to try and move it along. Whether or not an individual unit owner can attend to observe is going to be up to the judge. While open court is open court, a case management conference, sometimes they want just with the parties. So it's really going to depend on the judge on that case.
Okay. Ken in Coconut Creek says our board is considering changing the canopy to a different color. Is that considered a material change, and do we need to get a vote on that?
Well, I'm going to assume that he's talking about a condominium because that's the only place that this issue would be relevant.
Right.
As many of our listeners in condominiums may know, that the statute provides that you cannot make a material alteration or substantial improvement except as provided in your governing documents. Necessary maintenance is not considered a material alteration, but the Division of Condominiums in Florida has concluded that the change of color is a material alteration based upon a misinterpretation of the case from the late 1970s, early 80s that involved a community that had a multicolor scheme that they went to one color, and the court said at that time that the multicolor was a material part of the community, so making it monochromatic was a material alteration. So the division took that court ruling and decided any change of color anywhere is a material alteration, which I don't think was the intent of the court at that particular time, but there hasn't been another case before the courts to hear that. So we take the approach that since the division considers it a material alteration, then you should be considering it so as well to avoid any problem. So you look to your documents to see whether there is a specific reference to an owner approval vote for a material alteration. Sometimes those provisions will be tied to a threshold, like a specific dollar amount or a percentage of your annual budget. When you have those types of thresholds, it doesn't typically cost any more to go from one color to another the painting is maintenance, the change in color would be the alteration. Since the cost is the same and you have a threshold of $1 amount, then that would not require a vote of the owners. But if it's just any change requires a certain percentage vote, then you would need that owner vote for perfect safety.
Okay. Ben from West Palm Beach, the difference between 48-hour notice and a 14-day notice, what is the difference?
Well, my first thought is 12 days.
Okay.
That's a joke, right? 48 hours is 2 days, 14 is 14. But there are certain things that the statutes require 14 days notice and some things 48 hours. Typically, regular board meetings require 48 hours posted notice. If you're doing a special assessment or certain rule changes that affect units or adopting special assessments, then you're going to be required to do a 14-day notice. Your annual budget in a condominium requires a 14-day notice. So it really is going to apply to different situations.
Okay.
It's not all that complex.
Okay. Well, tell you what, we ran a little long last time. We're going to go to our last commercial. We don't play a commercial in the second half of the show. We're going to do our commercial here. And again, please give everybody the phone number, Robert.
You can reach us at 800-974-0680.
Okay, we're going to go to break and we come back. And I promise we will do, someone just texted me about, are you going to do the calendar again? I promise you we'll do the calendar again in the next 30 minutes. If you want to call in here, the phone number is 888-565-1470 if you've got a question for attorney Robert Kay. We'll be right back.
K. Bender Rembaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida, with offices in Pompano Beach, Palm Beach Gardens, Tampa, as well as in Miami-Dade by appointment. Several K. Bender Rembaum attorneys are board-certified specialists in condominium and plan development law, and they assist clients with all matters of community association legal issues while keeping them up to date on new developments affecting their associations. K. Bender Rembaum is also a well-known provider of free legal education, which often includes CE credit for managers and state certifications for board members. Contact K. Bender Rembaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or just write to them via email at info@kbrlegal.com.
And we are back. This is the Ask the Expert Show. I'm host Steve O. I'm here. This is the first Thursday of the month with Ask the Experts. And for the last 4 years, we've always had the K. Bender Rembaum law firm. They do a community association, and they are one of the largest community association law firms in the state of Florida. And I got to tell you, we get so many compliments off the show, so many people writing in questions. People are a little antsy today. We've had 3 or 4 calls in, and they didn't want to hold. That's okay, because we have got a ton of questions. Let me go to Julie in Hollywood, who says, we have a board of 7, and one of the members chooses never to come to the meetings. Can we get rid of a board member who refuses to show up, or do we have to wait for the elections?
Well, there are a couple of things that are available in that situation. One would be whether or not the documents provide for so many unexcused absences from meetings to be considered a resignation from the board. That would be a helpful provision. Many communities have added that by amendment. It's not a typical standard provision that we see, but that would be one way to address that type of issue. Otherwise, other than the election, they would have to do a recall, which would require the collection of a majority of the owners' signed agreements to present to the board for the removal of that individual. If recall is the approach that they want to take, they have to do that not 60 days before or 60 days after the annual election. So the timing of that completion would have to bear in mind when their annual meeting is.
Okay. Oh, you're going to like this text that just came in. This is a board that just took over a brand new condominium, and they wanted to know if you do Zooming, and I know you do that, but they also want to know if you provide a handbook of everything they need to do. How do you set that up with new clients, Robert? Because there's so many things that they need to know.
Well, when a group of owners takes over operating an association, there are a great many things that they will need to know, and they often don't. And it's important to make sure you have a sufficient base of experts to assist the board. You would need good management. You would need, obviously, the good attorney. You need a good accountant to get you off to a good start in operating the community. The accountant's function would be to review the financial records that the developer had maintained to make sure that the funds were properly collected and spent on association issues, not developer issues. Make sure that the developer doesn't owe the association any money for improper use of association funds. Management is obviously important to assist the board in all of the physical aspects of operating their community. And of course, the attorneys would be here to help them to understand what their rights and obligations are in taking control, what options they have in addressing any defects in the community that the developer may have created, and as well as assisting the board in getting itself positioned for the future and the operation of the community, reviewing the documents to make sure that they are as the board would want them to be or as the owners want them to be going into the future, whether changes are needed, desired, necessary, and all of that. There is no handbook on that, unfortunately, because every community has its own unique set of facts. So you couldn't really create a handbook that's going to cover everything unless you're going to get a book that's very large, and then no one's going to want to read that. So, we can help guide them through all of that.
So, Robert, normally when the developers turn over the property and there's a board there, they don't really know very much, do they?
Sometimes they do, sometimes they don't. A lot of times people come from one community to another, that they bought into a new community, but they've got experience in an association. Associations have been around here and they're very pervasive throughout the state of Florida, so a lot of people have some involvement with them. Do they know everything they need to know? Of course not, unless they're professionals in the field and deal with it on a day-to-day basis. And again, that's why they do need to have the good expert assistance. Also, I didn't want to forget, a good engineer is likely going to be necessary to do a once-over on the property to make sure everything is built correctly in accordance with specifications and appropriate construction standards.
Are you still getting a lot of calls about swimming pools with the pandemic?
Not so much anymore. I mean, most of the restrictions have been lifted, so now each community is in a position to decide their own fate and what they're comfortable with. They still have the entitlement and authority to close or limit the use of certain of the amenities under the circumstances. But as we're seeing more and more people are being vaccinated, and I think we're seeing a lot more looser standards across the board. And people are a little bit less obsessed as they had been, and properly so.
Phone number here is 888-565-1470, 888-565-1470. You know, this is getting scary because some of these questions, from being on the show with you for so long, I could almost answer myself. Here's one. Can a unit owners put their money in a separate account if they don't like the way the board is using their money? I know what that one is.
Yeah, what's your guess?
I would say no. They're not allowed putting money in. They can't.
Well, if they do, they're risking having additional expenses tacked onto it by attorney's fees and costs of collection, and the possibility of ultimately losing their home. There is case law in Florida that specifically provides that the obligation to pay your assessments is a separate requirement from the obligation of the association to do what it's supposed to do, be it maintain the property or how the board spends the money. The owners elect the board, so that's their function, to spend the money. And as long as they're using their appropriate business judgment, their opinion is what the court is going to go with, not that of the unit owner who disagrees. So if you disagree with how the board's spending money, your answer is get enough like-minded owners together and become the board yourselves through the election process or the recall process, and then you can be the ones everyone's taking the pot shots at.
Okay, so let's go to Douglas in Vero Beach. Hello, Douglas. Douglas, are you there?
Hello.
Hi,
Yeah,
Douglas.
is here. Sorry.
Good. You have
Hi,
a question for Robert?
An excellent. I do, and I just got on. I'm sorry if this has come up, but I'm going to join in, and you're doing an excellent job. This is quite a community service. My question, sir, I have two. The first one pertains to the new legislation that will be going into effect if it's signed. I'm sorry I forgot the Senate bill number, but you'll know it when I mention it. It's about 130 pages, and it includes, among other things, some changes in leasing provisions for HOAs. And my question is, I understand that if we're going to make any changes in our declarations for our existing my opinion is we ought to do that in these remaining 30 days prior to July 1st, because otherwise it would not be immediately applicable to residents in the future who voted no. If you're following that question, what I need to find out is it incumbent on us to also update our rules and regulations to conform with the new changes in the declarations by July 1st, or can those changes be made subsequently?
Well, for those listeners who aren't aware, one of the changes that have been passed by the legislature for HOAs is similar to what's been in the condominiums for the past 14, 15 years, and that is if the community amends the documents to limit the ability of an owner to rent, creates those types of restrictions, it's only going to apply to those owners who vote in favor of it or those who take title after the amendment is effective. And those who didn't vote in favor of it, those who didn't vote at all, would be able to continue to operate as they had prior to the change. So for homeowner associations that want to have rental restrictions that they don't currently have, you are correct that it would be advisable to get those changes drafted, presented, and adopted by the membership prior to June 30th of this year, and recorded in the public record prior to that date as well. That's a tall order in the short amount of time. And this is all being done with the expectation that the governor will eventually sign off on it, but may not. So it could be a rush for nothing, but it makes good sense. I think the likelihood is that the governor will sign the bill. It's just a matter of when. And so that all would need to be done before July 1. The rules you're referring to conform to that can come afterwards. Only the change in the declaration needs to be adopted and recorded prior to the change in the statute.
Well, that's exactly what I needed to hear, and I'm pleased to hear, because obviously that gives us a little more time on that front.
Well,
as you said,
there is another legal issue that could apply, and that is there's this concept in the law that's referred to as the Kaufman language, in which your documents have to contain an express statement that says that the covenants are subject to the statute as it exists and as it may be amended from time to time. If your documents do not have that language in it, and this change in the statute occurs, there is a strong legal argument that it doesn't apply to your community because it is a substantive change in the statute that affects vested rights of your owners, and that cannot be a retroactive adoption by the legislature. It doesn't apply to your community unless you adopt that Kaufman type language into your documents or otherwise subject yourself to this change. So that's another concept that people need to bear in mind with this particular change. It's unusual for homeowner associations to have the Kaufman language unless they've amended to put it in. So that's something to look for in your documents, and that might make your situation a little bit more tolerable.
That's an excellent point, and I appreciate you bringing that out. May I shift to a second issue, please?
Okay.
Yes.
That one deals with, and this is just general, I'm fairly new here with Florida HOAs, but it's an issue I'm sure comes up all the time, and it's parking on the street. I'd like to get a sense, the declarations that were in place when I bought into the HOA said that you cannot park on the street. That is to say, you need to park your private vehicles either in your garage or on your driveway. And we have folks who didn't read or misread or what have you, and occasion they have multiple cars and they're leaving them on the street. And what I'd like to ask you is, do you have a sense of the relative frequency with which HOAs employ such restrictions? To me, that's a very reasonable one, and I'd like it to remain as it is, but I'm trying to understand, is that fairly unique, fairly rare to prohibit parking on the streets, other than, of course, commercial deliveries and maybe on a birthday party, that kind of thing, or is that fairly common?
I think that it's less likely to happen for a complete ban on street parking 24/7. Normally, we see that as a restriction for overnight parking, and there is some allowance for some daytime use. Some of the issues that are involved is the narrow streets, the ability of emergency vehicles to access if they need to. Some communities have rules in place that allow for parking on one side of the street or the other, and they alternate on the days of the week of the month, so that both sides of the streets get used. But if the streets are private and the covenants provide for the restriction, the board needs to enforce that. If the board's not enforcing it and allowing vehicles to be parked on the street, and that's been ongoing for a period of more than a year, there's a legal defense to an enforcement action, which is called waiver, and that the board has not properly enforced and has now lost the ability and would need to republish that restriction through the process of mailing to everyone the fact that they're going to start enforcing again as of a specified date and begin again. Vehicle parking is a little bit easier on republication because every time the vehicle moves and comes back, it's a new violation. So somebody can't say, well, I've been parking on the street all along, you can't force me to go. You've waived that as to me. Without action, that would be true. But if the board takes the proper steps to reenact the restriction, then they should have no issue with enforcing on that. And enforcement can be by towing. It can be by legal action to get an injunction to get people to stop. Towing, it tends to be more effective. But you also have the problem of what are people going to do with these cars? So it isn't as black and white as it could seem.
A tremendous answer. And I'd say in our own case, we just need to get some clarity from our board as to what does our language in fact mean. And I think we've got some confusion as to what's happening. That is to say, someone might be moving their car early in the morning while many of us are still asleep, and it might appear to have been there overnight, but these are all fact situations. But may I ask for clarification, if we are updating our, to tie the two questions together, if we're going to update our declarations so as to take full advantage of what our desired leasing policy is going to be pre-July 1st, would the very fact that we republish our declarations with that kind of change, but simply repeating the old existing parking language, constitute what you say as republication?
No, the republication process requires there to be a specific identification of the item you have failed to enforce and a statement affirming that you're going to start enforcing it again.
I see. Okay. And this holds whether or not you've had a new board and you're still fairly new HOA and you're getting your act together. Is it your position
yes.
that? Yeah. Okay. All right.
One corporation.
Yes. Well, that makes sense. Well, again, thank you for doing this. I'm quite impressed, and I look forward.
Are you a
to
board member? Are you a board member, Douglas?
Committee member and someone that does all I can to assist. Had a lot of experience.
Certainly, if the board needs legal assistance, we do cover Vero Beach.
Understood, and I think that's a very reasonable thing to do. Put yourselves out there, help us become aware of you. So thank you for doing the same.
Thank you, Douglas.
Right, thanks for listening.
You bet. God bless you all. Bye-bye.
God bless you. Okay, you know what I promised people that
I know you did, so let's jump right in.
Let's jump in.
June the 9th, the latest on the 2021 legislative session. Bills that have been passed but not necessarily signed into law yet. Discussion by Allison Hertz and Sean Brown at 11 a.m. to 12:15 p.m. On June 11th, how to negotiate telecommunications contracts. Panel discussion with Andrew Black, Representative Hotwire Communications and ACAM Property Management, 10 a.m. to 11 a.m., June the 11th. These are all Zoom. June 16th, condominium board member certification, 10 a.m. to 12 noon. There's continuing education credits for managers. State certification for new board members. Lisa McGill will be instructing that. June the 23rd, funding construction projects. Also some continuing education. co-presented Campbell Property Management and Michael Bender about financing these construction projects through loans and other methods. Very informative, very good course. June 23rd, 12 noon to 1 p.m. June 25th, we'll do another summarizing of the 2021 legislative session at 10 a.m. to 11:15. Allison Hertz, hosted by Community Association Resource Group. We might have a better idea then what's actually becoming the law on July the 1. And then on June the 29th, Association Leadership by Castle Group, a panel discussion with Michael Bender and Jeff Rembaum, as well as representative of Castle Group. All of these are on Zoom. They're all available on our website. You go to kbrlegal.com, click on the calendar, and you'll be able to choose the one you want and RSVP for your attendance and get registered so you can get the Zoom hookup. Also, on our resources page, we have the bills that have been adopted available there. So you go to click on resources and choose new legislation, and you could read for yourself the fun language that may become effective next month.
Okay. Here's somebody from your
One
neck
last
of the woods.
question before we have to go.
Yeah, Joe in Pompano. He wants, oh, Joe, he wants to know if this is for a condo. Is there a limit on the amount of reserves a condo can hold before they decide to spend the money on improvements or give a refund to the owners?
Well, your reserves, you're supposed to have periodic studies by an independent expert to tell you how much reserves you need for all of these items, what the useful lives are for the various assets that you're required to have reserves for, and then fund them accordingly. When you reach a point where you have enough money to cover it and it's not needed yet, you can hold on to it. You don't need to add to it. You shouldn't keep adding to it. It's not typical for an association to give money back. If there's excess proceeds in a reserve account, the board can shift those funds to other purposes without a vote of the owners. But if there isn't sufficient funds to meet the needs of the association, you can only shift those funds with a vote of a majority of owners participating at a meeting at which a quorum has been attained. So you need that outside reserve study, and that should be done every 3 to 5 years so that you make sure that your reserves are kept up to date in the proper amounts.
Well, we've only got a couple minutes, and I got to save one of those minutes for you to tell people how to reach you and get a hold of your, if they want to reserve space for your your schedule, your calendar for the month of June. This lady, I promised her, she wanted to know, I said, I promise you I'll get you on today. If a condo owner wants to question the board of directors, what are they supposed to do?
Well, you can attend a meeting, and if there's
about a decision.
The first thing in a condo is that you should send a letter by certified mail and make an inquiry of the board for a substantive response that it has to be provided to you within 30 days, unless it's sent to the attorney for response, in which case it would be 60 days, but they'd have to tell you within 30 that they're doing that. That's the typical method of getting an answer. If you don't get an answer to your question within the time frame provided by the statute, then you could consider taking that to the Division of Condominium, either through the enforcement section, which may or may not get involved, or through arbitration. You could hire an attorney to make the inquiry on your behalf if you don't get the appropriate response. That's sometimes will get the answer that you're trying to get, because the board sometimes are more responsive to outside attorneys asking these types of things. But the other method would be go to a board meeting and ask the question during the meeting, and and hopefully you get an answer in that instance. Board should be communicative to their owners and responsive to their questions. That's basic to community association operation. They're not always, but they should be.
There's our music. Callers, one of them was from Philadelphia. Please call back. We'll be on the first Thursday of the month in July. Give everybody your phone number, Robert.
Reach us at 800-974-0680 or go to kbrlegal.com, info@kbrlegal.com.
You are the best, I'm telling you. K. Bender Rimbaum, they're with us the first Thursday of each month. We'll see you again next week with more Ask the Experts. Thank you, Robert.
All right. Good night, everybody.
Thanks for listening to the Ask the Expert Show, featuring interviews with local experts in the fields of legal, health, financial, and home improvement. Call our office at 888-574-6999 to become one of our experts on the show. And tune in again next week for more Ask the Experts with Steve-O.
The opinions expressed